Hey, what's going on, guys? Back again. Alright, just got back from court. Today is June 12th. This is a follow-up to my court regarding the Salt Lake City case. So I went today to my bench trial, and I also have a full audio recording that will play after this. Basically, I'll let you find out what the verdict is going to be by listening to it. It was pretty challenging, you know. I'm slowly finding to learn a lot more through trial and error and through going through those trials, you know, learning. So I'm finding out more and more that the court play by their own rules, and you know, they don't like when you bring all the rules to their games. They very much have their rules pretty much set the way they want it to be, and that's pretty much it. So on that, I will let you guys go ahead and listen to the audio recording of this court. It's a little longer today for my bench trial. And oh yeah, also one thing too is that I did have the option between bench trial or jury trial. But after researching the information online, I found out that bench trial, you can argue law with the judge, where you know, a jury trial where people comes up and you have a jury trial, you can only argue like the case, you can argue regarding the case basically. So that's kind of why I choose to go to a bench trial instead of a jury trial. So anybody, any comments, any suggestion? Let me know. I will post another video. Go ahead now and listen to the audio. Thanks for watching and thanks for listening.
Just be patient and firm and hear the case.
Sure, yeah.
So I don't see any pleadings found in this court.
Yeah, I haven't entered any plea.
I'm sorry?
I haven't entered any plea, so I haven't entered any plea in this case.
I understand that that's your belief, but having come before the court and saying that you don't wish to plead guilty, you don't believe the court properly has jurisdiction, the court denied your point of view, if you will, or your motion for a finding that jurisdiction is not proper here, and instead set the case for trial. So if there's something further that you'd like to offer, I will hear it. Otherwise, we'll go ahead and proceed to trial.
Okay, well, before we start, can I ask a couple questions, if it's possible?
What would you like to ask?
First question I wanted to ask. Let me see. When am I able to ask for the judge oath of office and the registration?
I'm not sure I know what you're asking for.
What I'm asking if we can put your oath of office and your registration on the record.
I don't have a record, so no.
On the record of this case, that's what I mean.
This is a court not of record. I don't have a record. I can't.
Oh, there's no record. Okay.
This is a court not of record.
Okay.
This is considered a justice court, so
All right.
effective next month we will record the proceedings that occur here, but right now we don't actually record those proceedings.
Okay.
It's considered to be a court not of record, so I can't put anything on
Okay.
the
On the
record.
record. Okay. So how would I be able to check on your ability to actually perform as a judge? I mean, is there any document that you can show me that you can produce
I
to me?
imagine you could go to the city recorder's office and ask for a copy of the oath of office that I took when I became a judge, and then I think the court, I think I'd had to take an oath every 4 years when the court recertifies.
Okay, but you don't have it here today?
I don't keep a copy of it, no. city
Does the clerk
recorder
has one?
does. I'm sorry?
Does the court has one here? Is there one here?
You could probably make a grandma request with the court and ask for such a thing.
Okay.
I think you could make a grandma request, and then if that document was not kept in the court by the chief court administrator. It's possible that he would forward that request to the city recorder. And certainly the city recorder keeps it. The AOC, Administrative Office of the Courts, keeps a copy of it.
Okay, so, you know, if possible, I'd like to have the document before we can actually proceed, so I can make sure that, you know, you're fully, you know, able to administer this case.
Okay, I understand your motion and I'll deny it. I've been a sitting judge for 10 years, come July 1.
Okay.
And I know of no reason why I don't have the authority to hear this type of case. I've heard so many hundreds of cases of this type that I'd be quite surprised if jurisdiction was not proper here. So I deny your motion. I think it only builds delay, and I don't see any justification to grant such a motion.
Okay, what about the delegation of authority order that I actually asked on my affidavit? I think I entered an affidavit.
Sorry, the delegation of authority?
Yeah, it's on the affidavit that I've entered.
And that's what Judge Robinson previously denied.
Are you able to?
Whatever you previously offered as your affidavit that you...
That one.
I'm not sure what your affidavit is intended to communicate.
What do you mean?
Just that you reserve your rights. I'm not really entirely sure what you're intending to communicate to the court, but that was ruled on by Judge Robinson, and again, I don't find any basis to continue or delay the case.
No, I'm not actually delaying it. I mean, it is, you know, the Constitution states that I should, you know, before I actually engage, you know, into a study, you know, in a court, I should make sure that jurisdiction is actually correct and everybody have their oath of office, you know, and such. And that's what I'm actually asking for. So I'm just.
As I said, I was in the group of the judges elected by, not elected, but appointed by the mayor to sit as the judges in this court when this court opened in 2002, and I've been a judge since that time continuously, without removal. I've been retained by the voters. I know of no reason why I don't have jurisdiction. I know of no reason why this court does not have jurisdiction. You'll have already heard a speeding ticket previously. The first case call involved a suspended license charge, which are the two charges that you have. I know of no reason why this court does not properly have jurisdiction.
Okay, well, I can take your word for it, or I can actually see something that shows that.
I don't know what you'd like to see. For example, if you've done some research ahead of time, if you looked at the website for the state court systems, you would see that Salt Lake City has a justice court and has for 10 years. And that's this one. I don't know what I would show you, so I think we just need to proceed. Do you have something else that you need to offer at the outset?
Well, I'd like to start here, but obviously I can't have any of those documents, you know.
The name up here on the board is my name.
Okay.
It's been here for 10 years. I've been assigned this courtroom.
Okay.
Some of the officers here have been appearing in front of me for the last 10 years.
Right.
Mr. Swift's not quite old enough to be here. I know of no reason why I can't hear this case.
Can we deal with matter of common law here, or?
No.
No?
This is a statutory court created by statute, passed by the legislature.
Okay.
And the system of justice courts has been upheld by the Utah Supreme Court, in this state specifically, and also by the United States Supreme Court repeatedly, over and over and over again, when individuals challenge whether or not justice courts should exist. The highest courts of the land continuously and consistently say that such courts are constitutional and provide a resource of great value. So I know of no reason why this case can't proceed.
Okay, well, she would like to proceed, but I'm pretty sure, okay, well, I'll give my side of the story and stuff, but like I said, those are mainly for common law, since it doesn't involve, those are issue of common law because you actually involve a human being, it doesn't involve any like corporation, so.
Okay. I'm going to be denying all of that being offered because you need to understand, as I said, this is a statutory court created under the authority of the statutes of the legislature of Utah.
Okay.
So we're not going to hear anything based on common law. He is not allowed to charge you with a common law crime. You don't get to raise a common law defense. We're going to play this game by the rules set forth by the parties in power, and those parties in power are the legislature of the body of Utah, that works on the rules of the state statutes. You are charged under those rules, and that's where the law comes from.
So if
There are also sometimes city ordinances that are charged. It appears that in your case, you were charged with state code statutes. So we will hear state code charges. You may raise state code defenses, but no common law claim, no common law defense will be heard in this court. This is a statutory court.
Can I, if I may ask, how does somebody get charged with a statutory crime? What, I mean, are there specific?
Well, the city is here with an affidavit, basically in the form of the citation, with the witness appearing to be sitting next to the prosecutor,
Okay.
who's, I believe, going to, I presume, give testimony of facts in support of a violation of state law.
Is the plaintiff here today?
The who?
The plaintiff, is he here today?
The plaintiff?
Yes. Would I be able to
The
cross-examine?
party that is the plaintiff
Yes.
in a criminal case is the government. Mr. Swift represents the city prosecutor's office.
Okay.
The city prosecutor represents the people of Salt Lake City. That is the plaintiff.
So the plaintiff is not here today?
The
Then?
plaintiff is a party, not a person.
So how is it possible that I go to court against somebody that doesn't actually exist?
Oh, I think Salt Lake City exists. They've been paying my salary for quite a while.
Salt Lake City
And I
exists?
pay taxes.
Would I be able to meet Salt Lake City? I mean, it's not like funny or
Well, there's
anything.
me, there's him, there's her, there's that guy.
So you guys are the plaintiff?
Every resident of Salt Lake City is a part of the party of Salt Lake City. Anyone who
So I'm the
lives-
plaintiff too then?
Do you live in Salt Lake City?
I live here.
Ooh, that was a vague answer. Well, in any event, the party,
Mm-hmm.
people of Salt Lake City,
Okay.
if you've been reading case law, looking into the
I did actually, yes.
you'll probably notice that in some states, instead of saying state of Utah, you'll see the people of the state of New York. The reason for that is the difference between I'm suing you because you've irritated me beyond belief in the way that you've, say, operated your vehicle near mine. I sue you civilly for damages because you've insulted my sensibilities, and I say you committed a civil assault. That is me versus you. That's a private plaintiff versus a private defendant. But when the allegation is you violated a rule that applies to every single individual in the community, then the government becomes the plaintiff on behalf of the people. Mr. Swift represents one office. That office represents the people. The people represent the party bringing this claim. And the difference is that there won't be an award of money damages. There can be a deprivation of your liberty. Sometimes we impose only a fine. So it is true that in some situations, a party that is a plaintiff is an individual or a corporation, entity. It is true that in criminal cases such as this, the party that is the plaintiff is an entity much larger. The idea is that you violated a rule of common behavior, and therefore the people bring the case. That's what's happening here.
So if my physical appearance here, special appearance here today, prove that I am a human being of flesh or blood, how can it be in a claim which involve a corporation? I still don't get it. I mean, obviously people can see me here. I'm leaving. I don't.
I'm here representing Salt Lake City.
You represent who?
Salt Lake City.
Okay. Salt Lake City is where? I mean,
Salt Lake City is a city,
Right.
not a person. I represent Salt Lake City in this case against you. It's not like a civil suit where you get to, you do get the right to confront your accuser. That would be the trooper here.
So he's the accuser?
You will have that right.
So he's the one that brings the charges?
He's the one who issued the citation. I chose to bring the charge to the criminal court.
So you are the one that brings the claims against me? You are the plaintiff?
Yes, I brought the claims against you.
So you are the plaintiff?
My office, yes.
Well, I need somebody that somebody that is actually plaintiff, like somebody like me or you.
You will get to question the officer.
So he is the actual plaintiff?
He is not the plaintiff, he is the witness. Yeah,
So who is the actual plaintiff? I'm trying to see if there is somebody,
I'm not gonna do this over and over again.
I mean, I need to
You
fully
no,
understand this.
no, you need to understand, these are all individuals who also have the right to be heard. Time is
Okay.
running, we're not gonna keep going over this over and over again. So I've tried to give you the civics lesson, Mr. Swift has tried to do so. In a civil case, an individual sues an individual for civil damages. Maybe it's money, maybe it's specific enforcement of a rule of law.
So this is not a civil case?
When I'm talking, do not talk, okay?
I'm sorry.
Now, if instead a criminal case is going forward, a criminal case is brought forward by the body politic. It
Okay.
is the entire community of Salt Lake City, represented by this agency, and this one witness will be the witness who testifies in this case.
Okay, so let me ask, so this is a criminal charges, right, under statutory law, is that what it is?
Yes.
So would it be different from a criminal charges under common law?
Common law does not apply in Utah. We do not have common law crimes, we do not have common law defenses. If that's the basis on which you prepare, just close that folder up and set it aside.
Oh, no, it's not.
Because common law does not exist there are no common law crimes. If you go through the Utah Code Book, you'll find a section that says common law crimes are abolished. You're not being charged with common law crimes and you may not raise common law defenses. What's going to happen in this case is that Mr. Swift will call his witness. He will, in the form of questions intended to elicit answers, seek to bring forth evidence that would meet the elements of these two statutes you are alleged to have violated. So you're alleged to have violated two statutes. I ask that my clerk produce a copy of the formal information in case we don't already have it, to make sure that you know what you're alleged to have done. So the formal information that my bailiff is giving you
Okay.
is the document that has the elements of the offenses that you are alleged to have committed. The first of those charges is speeding, and that generally indicates that you operated your vehicle in excess of the posted limit. And in this situation, it alleges that on January 4th, 2012, at 800 East I-80, you operated your vehicle 79 miles an hour in a 65-mile-an-hour zone. The second charge, driving on a suspended or revoked operator's license, alleges that you operated your vehicle upon the highways of the state while the defendant's driving privilege was denied, suspended, disqualified, or revoked, a Class C misdemeanor. These two charges are both alleged to have occurred at the same time and place. They're both violations of Utah Code. The Utah Code annotated is the sum total or collection of violations that can be committed, so everything that's been prohibited by law by the legislature. These are the two violations that you are alleged to have committed on that date and time. Do you understand the charges?
I do not.
What don't you understand?
All of it.
That you were alleged to go to operate your vehicle 70 miles per hour in a place closer to 65?
Yes.
Do you have a problem with the math?
No, I don't. Actually, I'm
What's
pretty
your
good at
problem?
Well, I just don't agree to the charges. I don't actually understand them. First, I would like to start saying that, I don't know. It wasn't, are they claiming that I was driving a vehicle?
Yes.
Okay. I have to also actually deny that. I was not driving the vehicle. I was traveling in my automobile, which is completely different.
This is not the time for you to testify.
Yes.
I need to know that you understand the charges, that it's clearly before you what's alleged to have occurred, and that you have before you a copy of the elements. That's all we're talking about right now. This trial needs to proceed. So you're charged with two offenses. One is speeding, the other is driving on suspension. What's going to happen is that Mr. Swift will call his witness. His witness, I believe, will take the oath, take the witness stand, and then give testimony in response to questions that are posed to him. I will allow you to cross-examine the witness. I will limit your cross-examination to questions only. You don't get to engage in a dialogue with the witness. You don't get to ask the witness questions about the source of law, the U.C.C., the sui generis person. Nothing of that nature will come in. What you may do is ask questions that explore what this witness has testified to in response to Mr. Swift's questions. Mr. Swift can again redirect his witness. You may recross on the testimony given in redirect. When he's done presenting evidence, we turn the time over to you. If you choose to present a case, you may do so. When you do so, you are waiving your privilege of self-incrimination not being required of you, which is a constitutional right. If you choose to testify yourself, if you don't choose to testify, you don't have to. You may call any other witness who has knowledge of the facts or events, or if you had other kinds of evidence that you wanted to offer that are factually relevant to this case, such as photographs, diagrams, or something of that nature.
What about case
then
laws?
I'm sorry?
What about case laws?
You may argue case law in your closing argument, but that would not be evidence that would be offered during your case. So if you choose to present a case, you may do so. Presenting of a case is putting on facts that show whether or not the city's evidence meets the burden of proof.
Okay.
If you don't put on a case, they don't get to do rebuttal, but if you testify and you get to put forth a factual argument, or photographs, diagrams, whatever type of evidence you offer, he has the right to call witnesses or put on evidence in rebuttal, and then I will hear a brief closing argument from each of the parties and then decide the case.
One question. Would my affidavit be entered as evidence as well?
No,
Why not?
it doesn't seem to have anything to do with what happened on the date,
It has
January
everything to
4th.
do. It has to do with the law.
If you have a
What I'm
different
arguing.
affidavit that I'm not aware of, the affidavit that's already in my file has already been ruled on, and it doesn't seem to say a thing about what happened on January 4th at I-80 and
I guess
the
what,
reference post that is indicated to give the 1800 East as the address. So that's what I'm looking at. Right now, we begin with facts. And your affidavit seems to be kind of grasping it. There's a principle of law out here in the UCC, and I say it applies. And there's this thing out here, and I say it applies. I can't just say that that affidavit makes sense or has anything to do with this case just because you say it does. It has to have a factual nexus. I don't find one, we go forward. Okay?
actually, it does. I'm trying to explain the reason
That'd
why.
be a legal argument you can make in closing.
Oh,
If
at closing,
you
okay,
make
that's
one
fine.
that You'll be able to
Sorry,
tie it
I
together.
haven't done this before, so I'm not really familiar
You
with
may
it.
make a legal argument in closing. If facts support that legal argument, I will hear it.
Yes.
All right, Mr. Swift, call your witness.
City calls Trooper Fred Vincent.
Trooper, if you'll step up to my clerk to be sworn in.
Do you solemnly affirm the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Take the witness stand.
Trooper, if you could state your name and spell your last name.
It's Fred Vincent, last name is Vincent.
Where do you work?
With the Utah Highway Patrol here in Salt Lake County,
How long have you worked there?
on 9.5 years.
And in what capacity do you work for Utah Highway Patrol?
I work on the road, so the freeway, well, basically all the new traffic in Salt Lake County.
Okay, so does that include speeding enforcement?
It does.
Were you on duty on January 4th, 2012?
I was.
Where were you working that day?
That day I was assigned up on I-80 on the east side. I was up by the 17th East structure working speed.
Okay. Did you have an opportunity to come in contact with the defendant that day?
I did.
And do you recognize the person you came in contact with in the courtroom today?
I did.
Could you identify him for the court?
Yeah, sitting at the table with the black vest, white shirt, black pants.
Thank you. May the court reflect you identify the defendant.
Yes.
And where exactly did you come in contact with the defendant on that day?
Yeah, I was running speed on I-80 westbound. I sit just west of the 17th East structure. I'm sitting on the left side. I can see back up towards 2030s, so I can see cars coming down that hill, get a pretty view of them. I saw it was a 10 Cadillac. I look at my notes.
Well, yeah, before we get there,
Oh.
where you did come into contact or where you did see the defendant speeding, was that in Salt Lake City, Utah?
It was.
Okay, so now what is the first thing, please for your notes, what was the first thing you noticed about the defendant or the defendant's vehicle?
Like I said, I was parked on the left side. What I do is I just open up my driver's door and I lean out and I get the cars coming up behind me and I pull onto traffic and make the stop. At that time I noticed there was a 10 Cadillac Escalade using the fast lane coming down the hill through the vehicle passing easily passing other cars, obviously speeding. Was using a LiDAR at the time. Put it on the front of the vehicle, it showed 79 miles an hour. I tracked the vehicle with the LiDAR for approximately about 300 feet, so a couple seconds just to establish a tracking history with the LiDAR. Locked the speed of 79. That was he's 437 feet away from me at that time. He passed me, I pulled down the traffic and made the traffic stop, and he stopped I-80 westbound about 800 east.
Okay. So just to clarify what you said there, you got the defendant on LiDAR at 79 miles per hour.
Yes,
What is the speed limit in that zone?
65.
Is that clearly marked?
It is.
With what? How's it marked?
Basically, by about every on-ramp, there's a 65 mile an hour sign. It's the white sign, or rectangle sign.
Regular speed limit sign?
Yeah.
Okay. And so you pulled over the defendant?
Yes,
Was he the driver?
he was.
Okay. And did he say anything about the speeding to you?
No, I just advised him that I stopped him for speed and asked him for his driver's license and registration.
And was he able to give you his driver's license?
He was not. He gave me an ID card with his name and date of birth on it, and a picture, and then he gave me the vehicle had a temp tag, so I got the temporary registration.
Okay. Were you able to look him up with the ID card he gave you?
Yes, I went back to my patrol car. I was able to look up, type in his name, date of birth. I was able to look up his Utah driver's license. It also shows a photo of him, which was him.
Okay. What did you learn about the status of his Utah driver's license when you looked it up?
The driver's license had been suspended for failure to appear.
Okay. And can I have one second? I have no further questions, Ma'am. Thank
Do you have any questions for this witness?
Uh,
Okay, stand up here at the podium and ask your question.
no, I don't actually.
Okay.
I don't have any question for him at all.
You can step down.
And see you will rest.
Thank you. The case is submitted to you. Fabrice, would you like to call any witness or testify yourself?
No.
Would you like to make a closing argument, Mr. Swift?
No. I'll submit to the court.
Would you like to make a closing argument?
Is it, I can talk about this now, or?
Yes.
Yeah, okay.
But remember that having not put
Oh, no, no,
forward facts, all you get to do is make a legal argument.
Sure.
Make a statement.
So I noticed he mentioned that I was the driver.
The facts,
Yeah, get into it. And according to the definition, a driver is one employee conducting a coach, carriage, wagon, or other vehicle with horses, mule, or animal, or a bicycle, tricycle, or motor car. Black's Law Dictionary. What I claimed that I was doing that day is I claimed that I was traveling, and I was not actually driving, because there's actually two completely different understanding between driving a vehicle and traveling. According to Black's Law, to travel is to go from one place to another at a distance. To journey is spoken of voluntary change of place. The use of the highway for the purpose of travel and transportation is not a mere privilege, but a common fundamental right of which the public and individual cannot be rightfully deprived. Chicago Motor Coach versus Chicago, 169 NE 221. The right to travel is a part of the liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. Kent versus Dulles, 357 U.S. 116 125. The right to travel is a well-established common right that does not own its existence to the federal government. It is recognized by the court as a natural right. Chapman versus Dulles, 96 APP, DC 287 225, F2D 938 at 941. The state cannot diminish right of the people. Hurtado versus California, 110 U.S. 516. Where rights secured by the Constitution are involved, there cannot be rulemaking or legislation which will abrogate them. Miranda versus Arizona, 384 U.S. 436 491. The claim and exercise of a constitutional right cannot be converted into a crime. Milo versus U.S. 230 F 486 at 489. And also, I would like to state that I'm here in a traffic court, I'm assuming, which, according to the definition, traffic, it means commerce, trade, sales, or exchange of merchandise, bill, money, and the like, Black's Law Dictionary. So I'm assuming this court is conducting commerce. That's the reason why I've entered my reservation of right not to having to perform in any of those proceeding or whatever else you guys would like to actually get involved with. I've reserved my right to continue to travel on the roads. Like I say, if there is any evidence that I was driving, as it states here by definition, that I was employed in conducting, and if somebody spoke to my employer, I'd like to see, I'd like to have those proof as well. So this is my defense. Like I state, I was not driving, and I was simply traveling.
Anything else, Mr. Smith?
No.
I find you guilty of the two offenses. I don't find that any of the case law that you cited is relevant to whether or not you did not violate statutes that have both been, I think, upheld under Utah law, which is the applicable court. You should know, should you try to argue these types of defenses in the future. What's binding on me is the law that's passed by the state legislature, or it's a city ordinance that's alleged to have been violated, and the ordinance created by the, no, you're not interrupt the judge ruling, created by the city council. But when other cases come from other courts, they are only persuasive authority. And I find that the types of topics that the cases you've cited are so attenuated from what's at issue here that not only are they not persuasive authority, they're simply not relevant. Now, you know, you look for cases that you think put forth an idea that might help you, but I think it's been clearly upheld. I think if you pick and choose cases, as it seems you've done, I think you have ignored cases that have said that it's absolutely legitimate for the government to control who may operate a vehicle. So the right to travel may not be abrogated, but certainly the right to operate a vehicle on the roads and the highway may be. And each state does so in ways that are relatively consistent, although some differences exist from state to state. But I find that the elements of each offense have been met. That's all that I'm doing here today. All my job is to do is to find out whether or not the city meets the burden of proof, putting forth facts that show the elements of each of these two offenses have been violated. I find that there is competent and compelling and, in fact, highly persuasive evidence that you were operating a vehicle that was traveling 79 miles an hour in a 65-mile-an-hour zone, which puts you at a certain level of speed in the vehicle. And then also, I find that based on the evidence offered by the city, that your driving privileges were not valid. They were either suspended, revoked, or denied for failure to appear, which is a common outcome if we have a ticket issued in our court and someone doesn't come in. Failure to appear generally results in the person having a suspension. So either it's with an FTA perhaps out of this court or perhaps out of a different court, but either way, an FTA usually results in suspension. So I found you guilty of the two offenses. Would you like to be sentenced today? Would you like to be sentenced at a later time? You do have a right of appeal. If you wish to appeal, you may certainly exercise that right. But you do need to remember that that right exists only for 30 days. It is time limited. The 30 days begin after the entry of sentence. Would you like to be sentenced today, or would you like to come back another time?
Well, if I'm going to appeal, I need to be sentenced today, or because like I say, I didn't think this court would be able to actually discuss those,
Not sure really why that
my
would be thought,
argument.
but you might have noticed that this is kind of a general sort of
It's pretty,
course of business
yeah.
for this court. But
you know.
in any event, did you want to be sentenced today or another time? You can't appeal until sentence is entered, so if
Oh,
you want
okay.
to appeal, you might as well get sentenced today. You want to wait 30 days, I'll give you another date to come back.
Well, like I say, I really can't make any choices right now.
No, you can.
I-
Do you want to be sentenced today, or do you want to be sentenced at another time?
Is it like a plea that I'm actually entering? Because I don't want to enter any plea with,
No.
It's court.
Utah law says a defendant will be sentenced 2 to 45 days from the date of conviction.
okay?
That was a rule that was created, really somebody ought to go back and amend it, but it was a rule that was created when things didn't move at the speed and at the pace that they do now. And most people choose to have sentencing on the same day. Now, sometimes a person is so upset or so distraught that they prefer to come back another day. That depends on how much time you've got available. You got a lot of time on your hands, you want to sit in court 2 and 3 hours here and there, come back another day. Spend another few hours waiting for your case to be called. Or, if you'd rather move things along, have sentencing today, then you can file your appeal.
Well, that won't change anything, right? You already made your decision, right? So
Yes, I have. I
Oh, you already made the
I
decision.
found
Okay,
you
so-
guilty.
I guess it doesn't matter.
So are you saying you want to be sentenced today?
I mean, it's really up to you. Like I say, I haven't consented to these court procedures since the actual beginning. So I mean, you guys are just proceeding without me.
And I ruled that your consent is not relevant. You don't have to consent to a court
Under
procedure.
statutes, don't require consent.
No.
They do not.
No, you violate the law, city charges it,
Okay.
and guess what? Crimes before me. That's kind of where we are. So, would you like sentencing today?
I can't really say.
No, you will say. You're going to say yes or no, or I'll hold you in contempt. You're going to be sentenced today or sentenced at a later date, but you're making all these other people wait, and I don't know why that's fair. So, you want to be sentenced today, or do you want to be sentenced at a
we can do
later
it.
time?
We can do it today. If I'm being coerced into it.
City's recommending $165 standard bill account 1 and $300 standard bill account 2.
What would you like to say, sir, before we go forward? Anything else?
Yes, just very simply say that every time I get in the wheel of my car, it doesn't mean that I'm driving every single time. I mean, you can have a license, doesn't mean that you use it all the time. That's pretty much all I have to say.
Fabrice, if you're going down I-80, same road I'm going on, Mr. Swift's going on, Bailiff Bell's going on, any one of us, you're going down the same road I'm going down, then I think you're subject to the same laws I'm subject to. And my guess is if your car were on fire, you'd probably expect Salt Lake County or Salt Lake City to show up and put the fire out. But the problem I have with the individuals who come in here and say, the fringe on your flag makes your court unimportant or illegal, or the U.C.C. says you're not a natural person, sui generis files these papers and then nothing matters, is you want the benefits of government without the other things that the rest of us are willing to pay for. I find that kind of distressing. So you think that Salt Lake City Fire is going to show up and put out your burning car, but yet you have the right to drive without a license, even though I'm required to get one? Then it seems to me that you're asking for something that goes far beyond what we require of our citizens. You're asking for the rights of a citizen without the burdens of citizenship. And to me, that's kind of nonsensical. I don't understand it. I don't get why people think if I claim under these words that you should not have jurisdiction over me because I am a free agent, but please show up when my house is burning down, educate my children, and all the other benefits of living in a community, doesn't always sit well with public officials. So you might want to think about what you run on your arguments that you put before the district court judge on your appeal. You might want to consider that, because that's kind of the issue that the judges have, and the judges discuss when they're doing trainings about this kind of case, because we sort of find it problematic that a person is willing to, are you going to say that you get to drive down Interstate 80, but you don't have to pay any of the taxes that support the upkeep of Interstate 80? I don't think that's particularly fair.
I guess what I was really...
I'm giving you an idea so that you can maybe mull that over in your mind before you take your
I
appeal.
haven't hurt anybody. I haven't injured anybody. I just don't know why I'm here. If it's just for money, I don't know. I haven't hurt anybody. There's no injured party. There's no damaged party here. So that's the only thing I'm actually arguing. I mean, I shouldn't be here until I've actually hurt somebody. I understand what you mean with all the benefits that the government gives me, but I don't use them.
Okay. Well, you believe that you've not injured anybody. The city instead charged you with driving on a revoked license and speeding. And ask now that I impose a fine, and I'm going to do so.
Good.
On the speeding charge, I impose $265. I suspend $100. I expect you to pay $165, which is the standard bail for speeding at, I think it's 19 miles an hour, 14 miles an hour over the appropriate posted limit. Now that includes the $4 state security surcharge that I'm required by law to impose. Revoked license is a charge that's exempt from the surcharge. The standard bail is $300. What I impose is $600. I suspend half. My intention is for you to pay the standard bail, again, $300. So to clear this case with this court would require the payment of $465. Because the charges were both reduced to infractions at the last hearing, now the information that was filed actually says Class C misdemeanor, but it is clear from the record that the court did reduce the charges on the motion of the city at the last hearing. So they're both being infractions. The court cannot impose jail time. I can't incarcerate you, although I could hold you in contempt and incarcerate you, but all I can do, because they are both infractions, is fine you. So I've now fined you the standard bail. You either pay that bail, or you can expect that a failure to comply will issue, which will also suspend a person's driving privilege. So I'll order a 6-month period of probation. During that time, have no new violations of the law. The fines and fees are due within 30 days, or if you choose to appeal, your notice of appeal, if you choose to appeal, is due within 30 days. Anything beyond that time, it would not be accepted. So you can either appeal if you choose to do so, goes to the district court, or you can pay the fine. If you tell me that you're going to stay on probation here and pay the fine, you could ask me for a fine period that extended beyond 30 days. I'd certainly consider your request for a payment schedule. Based on your comments, I expect that you were going to appeal, and so I just gave you the same time limit that you would for your appeal. Do you have any questions?
No, I don't.
See my third grade paperwork, please.
Okay. Do I have to take it?
Yes.
I don't need it.
If you want to know the case number so that you can make your appeal, I would take a copy of it.
I don't have to sign anything, right?
I'm sorry?
I don't have to sign anything, correct?